You can find a summary of everything discussed in this video on CoinMarketCap. Kindly support my channel by pressing the subscribe and notification bell for this and other cryptocurrency news. Now, take a look at this. In the case of Ripple versus the SEC, Judge Netburn has issued a new scheduling order to move the XRP action. Ripple Labs and the United States Securities and Exchange Commission have issued a new scheduling order as a result of the ongoing legal disagreement between the two parties. The fact that Judge Netburn was recently nominated for the office of district judge in the Southern District of New York has not had any impact on the function that she plays in the Ripple case. She keeps on preside over the case with which she has garnered a reputation for making choices that are fair throughout the course of the proceedings. Taking into mind the decisions that she has made in the past with relation to this topic, this is considered to be a positive indicator inside the Bitcoin sector. An esteemed pro-crypto judge by the name of Judge Netburn was appointed to preside over the litigation that Ripple and the Securities and Exchange Commissions were involved in. This appointment took place on the last possible date for the SEC to provide a response. As a result of this nomination, the SEC was given an extension until April 29, 2024, in order to submit their opposition to the request that Ripple made. Following the completion of this, Ripple will have a total of 2 business days to reply to the request. Ripple and the Securities and Exchange Commission are engaged in a legal struggle that is not showing any signs of abating, and it has a greater heated than it has ever been before. The selection of Sarah Netburn to the office of district judge in the Dane District of the Southern District of New York has become an important development in the landscape of the legal system. There is a possibility that Ripple will emerge triumphant in the lawsuit that is now being supervised by Netburn and is being brought against Ripple by the SEC. The fact that she has a favorable attitude about cryptocurrencies and a reputation for making choices that are unbiased could be the determining factor. During a period of time that is of the utmost significance, the recommendation of Netburn is an appointment that is of critical importance. This unresolved conflict between Ripple and the Securities and Exchange Commission, and more specifically Ripple's unyielding opposition to the hefty fines imposed by the SEC, sheds light on the relevance of her position as a judge. Ripple has lately initiated legal action in which it has actively opposed the unreasonable demands made by the SEC and has given a counter-proposal wherein it proposes a maximum penalty of $10 million. As indicated by the fact that it has offered 3 persuasive arguments that contradict the claims made by the SEC and highlight changes in the manner that XRP is sold, Ripple appears to be in a strong position. This is demonstrated by the fact that it has presented these arguments. Ripple could benefit a great deal from the judgment that is expected to be handed down by the court, especially since it is carried out under the watchful eye of Judge Sarah Netburn. On the other hand, if Netburn makes the decision to support Ripple, the Securities and Exchange Commission might face major challenges, which would make it much harder for them to reverse her decision. Remarks from lawyers about the choice of Netburn has been welcomed with a significant amount of acclaim from professionals working in the field of law. Netburn got appreciation from Paul Grewal, the chief legal officer of Coinbase, who stressed her extensive knowledge of the legal challenges that are related with cryptocurrencies in the context of Bitcoin disputes. Grewal emphasized the significance of the role that professional judges play. I would like to extend my congratulations to Sarah Netburn, who is now serving as a United States Magistrate Judge in the Southern District of New York. She has been chosen to serve as a United States District Judge on the same court. She has arranged a masterclass session with the purpose of educating crypto and other individuals about the relevance of having exceptional justices in the Ministry of Justice. XR advocate Bill Morgan, who is known for his advocacy of the technology, also lauded Netburn's selection. Hugh highlighted her ability to make decisions without bias and her exceptional administration of the SEC versus the Ripple. The Ripple case has a number of grounds to applaud her. Morgan's support demonstrates Netburn's recognized judicial integrity and skill, showing that her elevation to district judge is rightfully earned and could be advantageous to Ripple's legal position. Morgan's support also underscores the fact that Netburn is a respected judge. A further indication that their partnership is a healthy one is the support that Morgan provides. During this interim period, Ripple has submitted a motion to Magistrate Judge Sarah Netburn, in which they expressly seek that the expert materials submitted. In the course of the litigation on the remedies, Ripple alleges that these crucial documents were brought to light. These records demonstrate that the Securities and Exchange Commission was unable to give a supplementary expert opinion on disgorgement. Additionally, they demonstrate that Andrea Fox, an assistant chief accountant for the SEC, made a declaration that was extremely important. Ripple believes that they were deprived of the opportunity to adequately argue the issues that were offered by the SEC because they were not provided with sufficient information. In addition, Ripple is critical of the Securities and Exchange Commission's decision to classify Fox as a basic summary witness. The company contends that Fox's analysis elevates her to the status of an expert and that her opinions should have been published sooner. Ripple's petition to be excluded from the process was met with opposition from the USAC, which resulted in the revision of the timetable for the succeeding meetings. Ripple's motion has the potential to have a significant impact, which might result in a shift in the SEC's perspective on the matter and have an effect on the overall outcome of this high stakes case, which would have repercussions for the cryptocurrency sector as a whole. It is possible that the decision of this case will have repercussions for the whole cryptocurrency technology industry. It is anticipated that the Securities and Exchange Commission will submit its reply brief by the deadline of the 6th of May. The deadline for parties and third parties to object to the limit on the number of details provided in the filings is the 20th of May. If Ripple had a judge who could be sympathetic to their case and who could hear compelling arguments, would it be feasible for them to finally see a light at the end of the tunnel? In all candor, only time will tell what will happen. Because it addresses the motion, this order is a very important ruling because it addresses Ripple's petition to reject the SEC's additional expert contributions. These submissions are intended to strengthen the SEC's case for remedies in a final judgment. Ripple's petition to reject these submissions is addressed in this order. Ripple maintains its steadfast stand against the Securities and Exchange Commission's assertion that it has beyond the legal mandates that it has been given. Ripple had opposed the proposed civil penalties that the SEC had provided, stating that a settlement of $10 million would be more acceptable than the $2 billion that the SEC had demanded. The current arguments in the lawsuit between Ripple and the CC are summarized as follows. Ripple had challenged the proposed civil penalty. Ripple, on the other hand, maintains that the allegations presented by the SEC are overstated and do not have sufficient evidence to support. Ripple has also questioned the basis for discouragement that the SEC has created, arguing that there is no substantial proof of financial harm that has been triggered by Ripple's conduct. This is in addition to the fact that Ripple has contested the grounds for discouragement. Furthermore, the defendants have utilized the Goebel case as a means of offering support for their viewpoint in order to bolster their argument. With regard to the business's corporate XRP sales, this case highlights the fact that there is no evidence to support any potential future violations or hazardous activity associated with the corporation. Ripple's argument is that any estimates of discouragement should take into account acceptable business experience. Any such estimate should be taken into consideration.